This video is intended to give a brief overview of your legal options. However, nothing contained herein shall be considered legal advice. This video doesn't cover all the issues you might encounter or discuss any particular issue in depth. Before proceeding with any legal decision, the best practice is to review your particular case with a knowledgeable attorney. Nothing in this video creates an attorney-client relationship. What is Chapter 7 bankruptcy and how do you file? Here is a quick overview of the process and steps involved in a Chapter 7 bankruptcy case. Chapter 7 bankruptcy is the most popular form of bankruptcy relief for individuals. The basic idea behind Chapter 7 is this: the bankruptcy trustee appointed to your case can sell your property to pay off your creditors, and ends with a discharge of qualifying debt, such as credit card balances, medical debt, and personal loans. Most Chapter 7 bankruptcy cases take about 4 months to complete, and move through the process without a hitch, but it's not for everyone. How filing for Chapter 7 bankruptcy works. Even though the trustee's job is to ensure that your creditors get paid as much as possible, many Chapter 7 debtors give up little, if any, property. State and federal laws allow a filer to exempt or protect particular property up to a certain dollar amount. If an exemption covers all of the property equity, you get to keep it. Because you're allowed to keep the things you need to work and live, most Chapter 7 filers protect everything they own and don't lose any property. Keeping a house or car when filing for Chapter 7 bankruptcy. If you are current on your loan payments and you can exempt all of the equity, you'll be able to keep the house or car. If, however, you are behind on your loan payments, or you can't protect all of the equity, you will most likely lose it. In that case, Chapter 7 wouldn't be a good option unless you were okay with letting the property go. Here's why. Mortgages and car loans are secured debts. You agreed that the lender could take the property if you didn't pay. Because of this, you can wipe out the balance in Chapter 7, but the lender will have the right to take the collateral, sell it, and apply the funds to the balance owed if you're behind on the payment. Even if you're current, however, if you can't protect your equity with an exemption, the trustee may sell the property. Other options include surrendering, giving back the property, or redeeming, paying the fair market value for the property. Qualifying for a Chapter 7 bankruptcy filing. Not everyone is eligible for a Chapter 7 debt discharge. You must take and pass the means test to qualify for Chapter 7 bankruptcy. If your income is lower than the state's median income for a family the same size as yours, you automatically pass the means test. If your income is over the state median, you'll get another chance to pass by subtracting your expenses. If you don't have enough left over to make a meaningful payment to your creditors through a 3 to 5 year Chapter 13 repayment plan, you'll qualify for Chapter 7. Keep in mind that even if you qualify, the court will still evaluate whether you have significantly more income than you need to pay your monthly bills. The court will compare the figures on Schedule I, your income, to those on Schedule J, your expenses, to determine whether enough remains to make a meaningful payment to creditors. Example. Suppose you make $5,000 per month, but your monthly budget shows you need only $4,500 per month. The court might order you to pay $500 per month through a Chapter 13 repayment plan, even if you qualify for Chapter 7. Bankruptcy exemptions are laws that allow bankruptcy debtors to protect property from creditors. Exemptions protect the same amount of property in Chapter 7 bankruptcy and Chapter 13 bankruptcy. The primary difference between the two chapters is that the bankruptcy trustee appointed to administer the case may sell non-exempt property in Chapter 7. The things the filer can't protect with an exemption, and the debtor will pay for non-exempt property in Chapter 13 through the Chapter 13 repayment plan. Exemptions in Chapter 7, protecting your property. Chapter 7 bankruptcy is a liquidation bankruptcy. A Chapter 7 trustee may liquidate the debtor's non-exempt assets, and use the money to repay creditors. Most Chapter 7 cases are no-asset cases, because most debtors can use exemptions to protect all their money and property. If the debtor is not able to exempt all his property, the debtor can either pay the trustee the non-exempt value of the property, or allow the trustee to sell the property. Once the trustee has the funds from liquidating the property, he or she will distribute the money to unsecured creditors in the manner the bankruptcy code requires. Example. If a debtor's car is worth $5,000 and the debtor exempts $4,000 of that value, the debtor can either pay the trustee $1,000 to keep the vehicle, or the trustee can sell the car, and pay the debtor $4,000 while distributing $1,000 minus sales costs to unsecured creditors. State versus federal exemptions. Both federal and state bankruptcy exemptions exist. You'll find the federal exemptions in Section 522 of the Bankruptcy Code. These exemptions allow debtors to exclude certain property from the bankruptcy estate, up to a certain dollar amount in value. In other words, filers keep exempt property. States also have exemption lists. Federal bankruptcy law allows debtors to use state exemptions instead of federal exemptions. But ultimately, states decide whether a filer must use the state exemptions exclusively, or whether the filer can choose to use one list or the other, but debtors can't mix and match between the two. Some states allow debtors to choose between state and federal exemption schemes. The remaining states require debtors to use the state exemptions. California is unique in that it allows debtors to choose from two different state exemption lists. Debtors using state exemptions may also use a list of exemptions called the federal non-bankruptcy exemptions. Which state exemption system can you use? The state exemption system you'll use will depend on where you've lived for the last few years. Homestead exemptions, exemptions protecting the equity in the home you live in, have different time requirements, too. Spouses can double some bankruptcy exemptions. Doubling in bankruptcy refers to being able to take twice the amount of an exemption available to you when you file a joint case with your spouse. Doubling allows you to keep more of your property in Chapter 7 and pay less to unsecured creditors through a Chapter 13 plan. When doubling is available, you and your spouse can each take the full exemption amount on the same piece of property, as long as you each have an ownership interest in the asset. Example: Ray and Ashley are married. They file a joint bankruptcy case in a jurisdiction that allows doubling exemptions. They own one car titled in both their names, as well as a house deeded in both their names. They also have a boat, which is in Ray's name only, and various household furnishings. Their state's exemptions law allow up to $4,000 for car equity, $100,000 for home equity, $3,000 for home furnishings, and $1,000 for boats. Ray and Ashley can double their exemptions on the car, the house, and the furnishings, bringing their exemption amounts to $8,000, $200,000, and $6,000, respectively. However, only Ray can exempt $1,000 of equity in the boat. Doubling federal and state exemptions. The federal exemptions allow spouses to double exemptions on joint property. However, whether you can double exemptions under state law depends on the state. Example: Ray and Ashley live in Michigan. Michigan allows bankruptcy filers to choose whether to use the federal exemptions or the state exemptions. Ray and Ashley choose the federal exemptions because they have a tax refund they want to protect, and Michigan law does not provide an exemption to protect it. Ray and Ashley can double their exemptions on any property they own jointly, including their joint tax refund. Example: John and Sally live in Louisiana and file bankruptcy. Louisiana has opted out of the federal exemptions, so John and Sally must use Louisiana state law to exempt their property. They own their house together, they are both on the deed. However, Louisiana law states that spouses may not double their exemptions for their homestead. The Louisiana homestead exemption at the time they file their case is $35,000, and they cannot exempt more than that of their home equity. When you can and can't double exemptions. You can double your bankruptcy exemptions with your spouse if all of the following are true. You file a joint bankruptcy case. State law allows you to double, where you choose federal exemptions. You own the property jointly. You can't double your bankruptcy exemptions with your spouse if one or both of the following is true. You're using state law exemptions, and the state law says you cannot double for that property. You don't own the property jointly. Example: David and June file a joint bankruptcy case, and choose the federal exemptions. They own a car worth $6,000 that June drives, but only David is on the title. Because June does not have a legal ownership interest in the vehicle, only David can use the federal motor vehicle exemption. What happens after you file for Chapter 7 bankruptcy? Once you know that you qualify for Chapter 7, and that you can keep the property important to you, you'll be ready to file your case. Here's what will happen next. You'll file the bankruptcy petition. You start the case by submitting a packet of papers, called the petition, with the court in which you disclose all aspects of your finances, including your income, debt, property, and property transfers, going back as many as 10 years. You'll also attach a certificate of completion showing that you took credit counseling from an approved agency, within the previous 6 months. In most cases, the course takes a few hours online or by phone. The automatic stay will stop creditors. Once you file your bankruptcy petition, an order, called the automatic stay, is put into place if it's your first bankruptcy filing. The stay isn't always available for subsequent bankruptcies. The automatic stay prohibits almost all of your creditors from continuing collection actions. Creditors cannot call you, collect money from you, foreclose on your home, repossess your car, or place a lien on your property. Exceptions to the automatic stay exist, however, and creditors can go into court and ask the judge to lift, remove, the automatic stay. You'll turn over supporting paperwork. At least 5 days before the meeting of creditors, you'll send documentation to the trustee, or the court in some jurisdictions, that proves the statements made in your bankruptcy paperwork. You can expect to forward your most recent tax returns, along with bank statements, paycheck stubs, and more, depending on the requirements of the trustee assigned to your case. You'll attend the meeting of creditors. Every filer must attend one meeting of creditors, 341 hearing, conducted by the bankruptcy trustee. You can expect the trustee to verify your identity, and ask you questions about your petition and finances. Creditors can, but often don't, appear to ask questions. You'll complete a financial management course. A filer must complete a debtor's education course, in addition to the credit counseling, received before filing for bankruptcy before receiving a discharge. The court will issue the bankruptcy discharge. After completing the requirements, the court will grant a bankruptcy discharge and the automatic stay will end. The discharge will not state which of the filer's debts get wiped out, however. Instead, it may list the types of debt that survive bankruptcy, such as domestic support obligations, recently acquired tax obligations, and student loan debt. The court will close the case. Shortly after issuing the discharge order, the court will close your case, unless the trustee hasn't distributed all non-exempt assets, or if you're involved in bankruptcy litigation. Thanks for watching. Please leave a comment if you want to see more videos like this.